Judge Beverly J. Cannoni served as the Regional Administrative Justice for Norfolk County until October 2024. Superior Court justices in Massachusetts typically rotate out of their leadership roles after 3 years. So, if she was cycled out in October 2024, but elected to continue in a special capacity, let's say, in order to see this case through to the end, does she still enjoy immunity for any of her own actions in court that normal judges enjoy? We're talking about judicial immunity. Judge Beverly Cannoni would still enjoy judicial immunity for her actions in court, but with important limitations, especially if she knowingly violated due process or acted outside of her judicial authority. Standard judicial immunity, or absolute immunity, generally shields judges from civil liability for decisions made in their judicial capacity, even if they're wrong, biased, or unfair. This falls under case law Stump v. Sparkman of 1978. Judges do not lose immunity just because their term in a specific administrative role ends, as long as they continue to act within the scope of their judicial authority. Limits to that judicial immunity might include if she acted in clear absence of jurisdiction. So if she continued overseeing a case in an administrative or judicial role beyond her lawful authority, she could lose immunity. Or if her special capacity continuation was not properly authorised. In that case, any actions taken after her term officially ended could be deemed extrajudicial acts which are not protected. In Maestri v. Jatovsky in 1988, the court ruled that if a judge acts in a case where they no longer have jurisdiction, they can be held accountable. I don't think that that's applicable. I think that that limitation is not applicable to her. But if her conduct violates due process or constitutes judicial misconduct, then maybe she won't be immune anymore. So if Judge Cannoni deliberately ignored constitutional rights, i.e. by suppressing a jury's partial acquittal, for example, it could trigger a federal intervention under Capitan v. A.T. Massey of 2009. Judicial immunity does not apply to cases where a judge's conduct is so egregious that it violates a party's fundamental rights. Case law for that is Dennis v. Sparks, 1980. If she deliberately refused to poll the jury, knowing it would expose a flawed conviction, she could face disciplinary review, even if she remains immune from civil lawsuits. If she engaged in non-judicial acts, like, for example, coordinating with the prosecution, she might lose any immunity, like improperly collaborating with prosecutors to shape a case. That comes from case law Miles v. Waco in 1991. Suppressing or manipulating evidence. That comes from case law Forrester v. White in 1988. Engaging in personal retaliatory conduct against the defence. Wonder about that one. If her role extended beyond merely presiding over the case and into prosecutorial or administrative misconduct, she could lose immunity. So just to summarise, while Aunty Bev likely retains judicial immunity for decisions made in her judicial capacity, even though she's been rotated out, she could lose immunity if she acted outside a lawful authority, violated constitutional rights, or engaged in misconduct. Assuming she had proper legal standing to continue overseeing the case, if she knowingly ignored due process to shield the prosecution, this could justify federal intervention. But that's not all.
There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed.
Right.
Is this a real concern that you have? Is this something that you are looking at, or have you just dismissed it as rumor?
I'll never just dismiss that as rumor. Something like that is, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence, that there was jury tampering? I don't have any specific evidence of it. Do I think that there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed, and who was dismissed very specifically? There were jurors who very, very clearly throughout, it's impossible to sit 8 feet away from 12 or 15 folks and not get an idea, just a chemistry idea of where those jurors are one way or the other based on certain, body language and facial expressions, etc., sighs and huffs and arm folds and leaning forward, leaning back, things of that nature based on certain witnesses. It's interesting that 3 of probably the most stalwart jurors who we believed, and I will go to my grave believing, were very supportive of the defense, ended up cast aside within minutes, not days or hours, within minutes of the jurors deliberating. Within minutes of me standing up and giving my final summation, those 3 jurors were gone. So is that a query? Absolutely. Have I dismissed it? I'll never dismiss it. Is there anything to do about it? Not so sure.
Bookmark that, because I'm going to come back to it. If the information that they were dismissed on came from a specific source, then yes, there's plenty they can do about it.
One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury?
Right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was a direct supervisor over the individuals that were testifying and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination, the presentation of our case. That person, that supervisor, we found out well into the trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest.
Is that standard in Massachusetts for just the DA's office to assign whoever they want to go be the sort of,
supervisor
of the jury? Yeah.
Yeah. Is it standard in Massachusetts? I hope not. I've never seen that in my life. But if I had a nickel for every time I said I've never seen this in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels. I've never seen that happen. It should never have happened. It's abhorrent to the system of justice in which we work. Those kinds of conflicts of interest, they just can't stand. But they did. And we weren't even told about it. I mean, that was one of the most galling parts of that revelation is that, wait, this has been happening under our nose the entire trial, and I'm just now finding out about it? We would have made hay about it as soon as we found out, and we did. But it was 10 minutes before I was about to stand up and close the case.
So is it judicial misconduct and procedural irregularity to appoint a state trooper to oversee the jury? The short answer is no. It is not standard procedure for a district attorney's office to send a state trooper of their choice to oversee or govern a jury on behalf of a judge. In fact, this is a serious procedural and ethical violation with potential due process and judicial misconduct implications. The fact that Judge Canoni appointed a trooper who was the direct supervisor of officers under federal investigation and who may himself be a subject of that investigation to oversee the jury and provide information that could have led to the dismissal of 3 jurors suggests an extreme conflict of interest and potential jury tampering. In Massachusetts, jury oversight is strictly regulated to ensure impartiality and independence. The usual court personnel responsible for jury matters includes clerk magistrates, court officers who are sworn employees of the trial court, and the Superior Court judge themselves. This falls under key procedural rules. Massachusetts jury instructions and common practice dictate that the law enforcement officers should not be involved in managing, overseeing, or interacting with jurors unless necessary for security purposes. The judge, not a law enforcement officer, is responsible for making juror-related decisions under Mass Criminal Law, paragraph 20. State troopers have no authority over jury management. This is a judicial function, not a law enforcement duty. Allowing an officer directly connected to a federal investigation to influence the jury is a blatant conflict of interest. If this trooper provided information that led to juror dismissals, that information should have been subject to open court review, not secretive communications with the judge. Judge Cannoni's decision to appoint this particular trooper, and perhaps even rely on his information to dismiss jurors, raises multiple red flags. A. Jury tampering or improper influence. Having a state trooper oversee or govern a jury, especially one connected to the case, violates due process. Period. If the trooper had direct or indirect influence over the jury, this could amount to jury tampering. If he had private communications with jurors or monitored their behaviour in a way that influenced their deliberations, it could invalidate the trial entirely. Under Remmer versus the United States, 1954, any external influence on jurors, especially from law enforcement, creates a presumption of prejudice. The burden is on the state to prove that no improper influence occurred. If Judge Cannoni privately received information from this trooper about the jury, that communication should have been disclosed to the defence. Failure to disclose such communications violates Brady v. Maryland. If defence was never given a chance to challenge or respond to the trooper's claims about the jurors, that's a serious constitutional violation. The relevant law that applies is Leuleberg v. Health Services Acquisition Corp. of 1988. A judge's failure to disclose ex parte communications that impact a trial outcome may require reversal. If the trooper himself was under investigation, this means that an individual with a personal stake in the trial's outcome was overseeing juror behaviour. Judge Cannoni relied on this trooper, effectively allowing a law enforcement officer with a vested interest in the case to shape the jury. The relevant law that applies is under Capitan v. A.T. Massey Coal Company of 2009. A judge's failure to recuse due to conflict of interest violates due process. A judge's duty is to ensure neutrality. If she appointed a compromised trooper to oversee the jury, she violated fundamental fairness. So what can they do about it? They can actually incorporate this evidence into the federal Habeas Petition, highlighting that the judge knowingly inserted a biased law enforcement officer into the jury process, preventing a fair trial. They can request that the federal court review this as part of the due process violations surrounding jury polling and judicial bias. Judges cannot delegate jury oversight to an outside law enforcement officer without a clear legal basis, which does not exist in this case. To summarise, law enforcement personnel such as state troopers, detectives, or local police officers are not supposed to have any role in overseeing or communicating with jurors. This is to prevent undue influence, intimidation, or bias. The presence of a law enforcement officer in a jury oversight role creates a clear conflict of interest, particularly when officers from the same department testified or were subjects of the investigation. These are drawn from Remmer v. United States, 1954, addressing outside influence on jurors creates a presumption of prejudice. Turner v. Louisiana of 1965, law enforcement officers cannot have undue proximity or influence over jurors during a trial. And Holbrook v. Flynn, 1986, a law enforcement presence in a jury oversight role could impact a defendant's right to an impartial jury. So if Judge Cannoni personally appointed a state trooper to govern the jury, she bypassed standard court personnel, violating trial procedure and due process. The fact that the trooper was the direct supervisor of officers under federal investigation raises serious ethical and legal concerns. Was he influencing jurors' perceptions of the case? Did he have private conversations with jurors that affected their views? Did his report to the judge cause the wrongful dismissal of jurors? If this trooper had direct or indirect influence over jurors, the integrity of the entire trial 1.0 is compromised. The defence should argue in their federal habeas petition that the trial was unconstitutional because of improper law enforcement appointment to oversee the jury. And at this point, if they haven't filed a judicial misconduct complaint against Judge Cannoni, they're mad. Because if the judge knowingly allowed an improper external influence, this could justify her removal from the case. And if she attempts to justify appointing a state trooper to oversee the jury by citing peaceful protests outside the courthouse, her argument is legally and procedurally flawed for several reasons. She had already issued a buffer zone and had local law enforcement ensuring compliance. If local police were already handling security, there's no valid reason to assign a specific state trooper by request of the DA to oversee or govern the jury. This undercuts any claim that appointing the trooper was necessary for security reasons. That argument would fail because a state trooper overseeing jurors is not a recognised security measure. Jury governance is not a law enforcement function, it's a court function. Court officers are the correct procedure to increase protection of the jury, and careful monitoring by the judge without inserting an external law enforcement presence. In Turner v. Louisiana, 1965, the US Supreme Court ruled that law enforcement officers should not be placed in a position of direct influence over jurors. The mere presence of a law enforcement officer in a role of authority over a jury creates an impermissible risk of influence. Well, gee, I wonder how the federal court will feel about that once they learn that the case actually is concerned with the death of a police officer. In this case, the trooper was the direct supervisor of officers under federal investigation, making his presence even more problematic. This specific precedent makes it nearly impossible for Judge Cannoni to justify appointing a trooper in this capacity. If protests were the issue, the proper response would have been to sequester the jury. If Judge Cannoni truly believed protests were a serious enough threat to juror impartiality, the legally appropriate action would have been sequestration of the jury, isolating them from external influences. Stronger court officer monitoring. Those would have been appropriate. She did not sequester the jury, which strongly suggests she did not actually view the protests as a legitimate threat. Instead, she appointed a law enforcement officer with a conflict of interest, which suggests her true intent was something else, i.e., controlling the jury process in a way that benefited the prosecution. The legal implications of her actions suggest improper motive. Under Holbrook v. Flynn, 1986, federal courts have ruled that using law enforcement in a way that creates a perception of intimidation violates the right to an impartial jury. But wait, there's more. What if the trooper played a role in dismissing jurors? Could it be considered jury tampering? Abso-freaking-lutely. The biggest problem with this appointment is that Judge Cannoni removed 3 jurors, and it could have been based on information provided by the trooper. If this trooper was reporting on jurors' behaviour or attitudes, this could be considered jury tampering. Jury tampering is a federal offence under USC 18, Section 1503, if it is done to influence or obstruct justice. If law enforcement officer improperly influenced the composition of the jury, this invalidates the trial. So what we're saying here is that Judge Cannoni's refusal to poll the jury is not in a vacuum. It is combined with her appointment of a law enforcement officer to oversee jurors, which violates the defendant's due process rights. And even that is not in a vacuum, because if that trooper was involved in any way in reporting back to the judge what the jury was doing, or saying, or whatever, that was also inherently prejudicial. Judge Cannoni's appointment of a state trooper to oversee the jury is not just an irregularity, It is a serious breach of trial procedure and due process, which could provide strong grounds for federal intervention. How, pray tell, are you going to explain this one away, Aunty Bev? Poof! There goes your judicial immunity.